Contracts 1. General Principles. Discharge of Contract Revised. Today's topic for discussion is Discharge of Contract chapter from Contracts 1. General Principles. In this lecture, I wish to cover meaning of the term discharge and discharge of contract. Various modes of discharge of contract by performance and non-performance is the topic for discussion today. In this lecture, I wish to cover meaning of the term discharge of contract, and then this discharge of contract takes place in two ways. One is performance, other is non-performance. Performance of contract takes place in different modes or different means. Discharge of contract by non-performance or failure takes place due to various causes. From performance, there are three modes or three means for performance of the contract. There are seven situations, 7 causes for breach of for discharge of a contract by non-performance. These totally 10 topics are to be covered in this lecture. This is a very big lecture. Some topics require simple explanation. However, some topics require detailed explanation. Now, before going to take up the meaning of the expression discharge of contract and means of performance and causes of non-performance, totally 10 topics, let me take just half an hour to pray God, pay homage to my reverend parents, late Regapurao, late Kantaratnam, and my wife, Mrs. Balivada Rega Tirumala Gauri. Let me express my deep sense of gratitude to my godfathers who are instrumental for what I am now. Let me express my heartfelt thanks and gratitude to the publishers of authors and publishers of textbooks and publishers of research papers and articles in internet, whose works I am making use of for bringing out this lecture. Finally, it is my duty to express my gratitude and irredeemable indebtedness to my student friends who are instrumental for what I am now. In particular, I wish to express my heartfelt thanks to my student friends for visualize my lectures and reach them to the tune of 10,000. Of course, there is about 9,990. These 10 subscribers may be completed today or tomorrow. Dear friends, let us now discuss about the topic discharge of contract. So, as enunciated in Hindu philosophy, yat bhavati tat nasyati, that means everything that is created in this universe will be destroyed or vanished one day or other. Similarly, every contract, that is every agreement which is created, constituted or entered into will be vanished, terminated, completed or will come to an end one day or other. Such completion of the contract or agreement, such completion of termination of the contract, such conclusion, such ending of the contract or agreement is called discharge of contract. Discharge of contract. This discharge or completion takes place in two ways: performance of contractual obligations and non-performance of contractual obligations by both the parties or either of the parties. So when a contract is entered into between two or more persons, some rights and obligations are created between the parties. The rights of one party becomes the duties or obligations of other party. The rights of other party will become the rights and will become the duties of one party will become the rights. So as enunciated by distinguished English jurist Salman, rights and duties are correlative. When one person has a right, other person must have duty. When one person would feel duty if other person will have right. Like that, when a contract is entered into, certain contractual relationships exist between the parties. So these contractual relations get extinguished, get extincted when the contract is completed. Just like birth and death, contract is created when parties entered into an agreement. Contract will be concluded or come to an end when parties discharge their complete their respective rights and duties. This is the meaning of contract. For example, a contract, A wants to sell his house to B for 50 lakhs. B agrees to purchase the house for 50 lakhs. If B pays 50 lakhs and A delivers the house and registers the house, the contract is concluded. Contract is concluded. Thus is what is called discharge of a contract. This is with reference to meaning of the expression discharge of contract. This discharge of contract takes place in two ways. One is performance. Performance means a contract is said to be performed if both the parties to the contract discharge their respective duties and obligations. The contract is said to be non-performed, not completed, if the respective part, both the parties or either of the parties have not yet completed their, did not yet discharged their contractual obligations. So this is why this performance, discharge by performance is three ways. One is promise, tender or offer of performance, tender or offer of performance. In this one item, reciprocal promises, an important topic, will appear. Section 51 to 58, including 52A, 9 sections lay down various provisions relating to reciprocal promises. Second type of performance is performance by joint promisors. Joint promisors. It relates to joint liability in civil litigation. So joint liability means when two or more persons jointly and severally liable for a particular activity, particular transaction, the persons are called joint promisors in law of contracts, joint tortfeasors in law of torts. So this joint liability will appear in Indian Penal Code under section 34 and 149 of Indian Penal Code, common intention and common object. In civil law, the liability is joint and several. In Indian law, in criminal law, the liability is only joint, not several, because the liability can be shared, apportionable, apportioned in civil liability, but it cannot be apportioned or shared in criminal law, because if 2-3 persons jointly take loan, 2 or 3 are jointly liable. If 2 are, that is why the liability is joint and several in Indian law. If it is 2 or more, 2 or 3 persons or 5 or above persons under joint object, common object, commit any crime, the liability is not joint and is liable but not joint. It is constructed because 2 or more persons jointly commit murder, all are equally liable for life imprisonment or death sentence. That if any they jointly commit for whatever offence they commit jointly, what is the offence prescribed under Indian Penal Code, they are liable. So this is with reference to joint performance by joint promisors or joint liability. Section 42 to 44 of Contract Act lay down various provisions relating to joint liability in respect of joint promisors. Third one is appropriation of payments. Appropriation of payments or devolution of liability. Section, this is also known as rule in Clayton case. So this there are three rules, 59, 60 and 61, three rules under Indian Contract Act. These rules provide rules for repayment of debts, repayment of a debt or debts by debtor to the creditor. What is the procedure to be followed for adjustment of the repayment made, or how the repayment made, if it is a part payment, is to be accommodated, adjusted or appropriated against various debts taken by the debtor, is the topic for discussion today. And in this Devyans versus Noble case, we will have to discuss. For the discharge of a contract takes place in two ways. One is performance of contract. The performance of a contract for discharge, for its discharge, takes place in three ways, namely tender or offer of performance or reciprocal promises. Second one is performance by joint promisors or joint liability, section 42 to 44, and appropriation of payments or devolution of liability, section 59 to 61 of the Contract Act. It is otherwise known as rule in Clayton's case, or the rule laid down in Devyans versus Noble Company. This is the case. This is with reference to performance. With reference to non-performance of a discharge of a contract by non-performance takes place in seven ways. There are 7 reasons or causes for non-performance of a contract. So a contract is said to be discharged by non-performance under various situations. There are 7 situations. Number 1 is discharge by impossibility of performance, or the Doctrine of Frustration, section 56, and in particular section 56 clause 2. Discharge by non-performance. Here, impossibility, any contract, one of the essential elements of a contract is an agreement is said to be valid provided the subject matter of the contract must be capable of performance. There must be possibility of performance. If there is no possibility for performance, if it is enforceable, that contract is said to be a void. For example, if an agreement is entered into doctor and a person to give life to a dead body. So no doctor can enter into a contract with someone to give life to a dead body. So no runner can enter into a contract with anybody that he will reach 100 kilometers, he will run 100 kilometers just in 1 hour. So they are impossibility of contracts, impossibility of performance. So this impossibility, initial impossibility is there, subsequent impossibility is there. Initial impossibility, known or unknown, is there. Known to parties or unknown to parties, known to one party, unknown to another party, whatsoever is named, it is initial impossibility or subsequent impossibility, known or unknown to both the parties, known to one party, unknown to one party. Whatsoever the reason may be, an impossibility exists or subsists in that particular transaction, the contract is deemed to have been declared void. That is, the Doctrine of Frustration is the first situation wherein under non-performance by which a contract is said to be discharged under section 56 with particular reference to section 56 clause 2. Second situation is discharge by subsequent agreement. This is known as Doctrine of Novation under section 62. Under this Doctrine of Novation, and old contract is closed and a new contract is entered into. The closure or cancellation of old contract will become consideration to the new contract. there are 4 situations under the Doctrine of Novation, section 62. I will explain in detail. Third situation is remission. Third situation is remission. This is a very small one. Here, what happens is the creditor gives some remission, concession, exemption or offer to close the debt, to clear the debt. So if suppose creditor gives 1 lakh loan and with interest it rose to 1,30,000, the creditor may ask the debtor to pay 1 lakh or 90,000, 1 lakh or 1 lakh without interest. It is called remission. That is third situation. Fourth one is accordant satisfaction. Accordant satisfaction. So the one party accords certain benefit for which satisfies the other party. The other party, it is called accordant satisfaction. Suppose they offer the buyer, the seller offers seller may entered into an agreement with the buyer to sell his house for 45 lakhs. 45 lakhs. But 50 lakhs. 50 lakhs. But in course of time, the seller is ready to sell, but the buyer is not willing to buy due to no funds or due to some other reason. Then the seller may ask the buyer, so not 50,000, I am ready to give it for 40 lakhs. I will give 10 lakhs concession. That is what is called, this reducing from 50 lakh to 40 lakh is an accord from one party. It gets satisfied with the other party, for which the other party agrees. So then it is called accordant satisfaction. Accordant satisfaction. So this also is said to be non-performance, because as per the strict terms of the contract, in strict adherence to the terms of contract, the contract is not concluded. That is why it comes under improper performance or non-performance. That is fourth. Next, fifth point is breach of contract. Breach of contract means failure to perform the contract. Failure to perform the contract or non-observance of the contract. When contract is entered into between two parties, both the parties are having obligations. Suppose a house is sold, seller has an obligation to deliver the house and register the house. Purchaser has an obligation to make the payment. The first obligation is on the part of the purchaser is to make payment, and the other next obligation and last obligation on the part of the seller is to hand over the house and register the house. Both the parties must fulfill the contract. If seller fails to, the buyer fails to pay money, it is breach of contract. Or after receiving money, if seller fails to deliver house and register it, it also breach of contract. It is also breach of contract. In Mohri Bibi case, Minors Act is called breach of contract. So this breach of contract can be explained under two ways: a present breach and anticipatory breach. What is the present breach? Means in apartment contracts and future agreements. I will tell in detail. So fifth one. Sixth one is discharge by lapse of time. Discharge by lapse of time. So a contract is to be completed within a particular period. Otherwise, the offeror asks the offeree to complete that particular, give his acceptance on a particular time. If beyond that particular time, the promisor has no obligation to complete the contract. It is beyond the time. Sometimes by limitation act also, the contract gets lapsed or outdated or vanished or concluded due to lapse of time. That is, this is discharged by lapse of time. Due to elapse of time, the contract may be closed or vanished. Last one is discharged by operation of law. The government may pass some GO, the government may pass some law. As a consequence of the government order, government GO or law, some existing contract which are allowed to be valid may be declared invalid. There is, suppose consumption of alcoholic drinks is allowed today. Suppose tomorrow new government comes and new government has taken decision to abolish consumption of alcoholic drinks. This legal activity will be made illegal activity. By that, those two parties who are doing this wines business, supply business, you have to stop. Yesterday it was valid. Today, as a consequence of the government legislation or GO regarding consumption of alcoholic drinks, it is not valid. So the contract may be, which is in a successful existence, may rendered invalid, discharged due to operation of law. These are the 10 situations under which a contract will get discharged. Now we have to discuss these points in detail. First one is tender or offer of performance. Tender or offer of performance. When a contract is entered into, one party makes offer, other party makes acceptance. When offer and acceptance are fructified, then only the contract agreement can be concluded. Provided that agreement fulfills the criteria under section 10, that contract will be valid. For example, A wants to sell his house. B also wants to expresses his willingness to purchase the house. A thinks, B thinks for selling and purchasing respectively. They do not comfort. Whether mere thinking in mind is no more useful, they must come forward. Similarly, our students, 1 month exams date, 1 month we should read today, like that. One day elapsed, 10 days elapsed, 15 days elapsed, 20 days elapsed, 25 days elapsed, 2 days there. Then they will go to market, purchase one book and start reading. That is called initiative. Mere thinking in mind is no more fructified, useful. So the parties must come forward to put the proposal in operation. The initiative must be taken either from the seller or from the buyer. The seller should approach the buyer. So I am ready to sell my house. Are you willing to purchase? You tell me. He should say. Then the purchaser should come forward and go to seller. I am ready to sell your house. Now I want to give you some advance. Would you like to enter into agreement or not? Either buyer must come forward or seller must come forward. Then only a contract can be completed. Otherwise the contract cannot be completed. So that is why, suppose in A wants to give his daughter to B's son. B also is ready to get his son married to A's daughter. But both are thinking. They do not take initiative. If they take initiative, one party goes to other party, makes a proposal, and then engagement, and then marriage. Then only the contract is said to be valid. So the offer from one side, offer from A, it becomes consideration to B. The acceptance from B becomes consideration to A. So A sells his house for 50 lakh. B is ready to purchase the house for 50 lakh. Then B's 50 lakhs becomes consideration to A. A's house becomes consideration to B. A's daughter becomes consideration to B's son. B's son becomes consideration to A's daughter. Like that. So the promises and proposals from each side are called reciprocal proposals, called reciprocal promise. This proposal becomes promise if the party comes forward to get the promise fructified. Similarly, the other party is acceptance gets fructified if he comes forward to accept. So the promise of one person becomes must be there to fulfill the contract from other side. So the activity of both the parties, acceptance or willingness to get the contractual obligation fructified, becomes promises to each other. These promises, mutual promises, are called reciprocal promises. These reciprocal promises are studied under section 51 to 58 of the Indian Contract Act, including section 52A. Totally 9 sections lay down various rules relating to reciprocal promises. With this, discharge of a contract by performance is over. Second one is discharge of contract by performance by joint promisor. Though this is second mode of discharge by performance, that is, performance by joint promisors or joint liability. When two or more persons jointly jointly enter into an agreement, all of them, one or two or more of them are jointly and severally liable. For example, A, B, C jointly borrowed 3 lakhs from D, and after particular time D can claim 3 lakhs from three of them, A, B, C, or two of them, or one of them. So if one alone is claimed, it is called several liability. If three are claimed, one person, if 3 lakhs they received, they share it more or less. One may take 2 lakhs and others may take 50-50, whatever it may be. When three persons jointly signed the promissory note, when they have, three of them have equal obligation to repay that money. Subsequently, they can adjust their contribution and recover from one another. Whoever receives more will give to the other who enjoys less. So that is secondary. But when once the obligation to keep up the promise is concerned, performance of promise is concerned, three are equally liable. Those three are equally liable, that liability is called joint liability. If one alone is liable, that is called several liability. In English law, only joint liability is accepted, several liability is not accepted. Because the creditor can sue three of them in or one of them in Indian law. In English law, the creditor can sue three of them. He cannot claim one of them. That is, in Indian law, the liability is joint and several. In English law, the liability is joint only, not several. Second point is, out of three promisors, suppose creditor has opted three of them to file a case jointly. If A dies, A's legal representative, the liability extends to A legal representative. Or B's son dies, B dies, B's legal heir, maybe son or daughter, will be liable. Or C's death. So the liability extends to legal representative also in Indian law, but the liability does not extend to legal heir, as enshrined in the maxim actio personalis moriter cum persona is there in England, but it is abolished in India. Legal representatives are liable. So this is the second thing. Third, fourth, 43. 44 in the sense contribution. Second one is 43 is contribution. Fourth one is the creditor will have an option to sue jointly or independently. For 42, 43 and 44 deal with. 42 deal with liability, joint and several. Second one is 43 deals with contribution or recovery of money whosoever paid. 44 deals with option of creditor to sue one party or all the parties. So with this, the joint promisor, performance of a contract by joint promisors is over. Next, third one is appropriation of payments or devaluation of liability, or section 59 to 61 as enshrined in this is called Rulings Clayton case. These rules are created in evolved in Daines versus Noble case 1816. This case is, there are some rules which are valid even for hundreds of years. Some rules get changed even in months and years also. That is why some even old cases which were in 1890, early 1900 also valid today in books. Some cases which were delivered last year may be outdated this year due to changes in the socio-economic condition. So in some way, even recent cases also, where judgments also will be invalid if any subsequent amendment comes. If oldest cases also will be valid if they relate to principles of natural justice and equity, which remain unchanged for generations and generations. The third one is appropriation of payments or devaluation of liability. So this is also called this is also known as rule in Clayton's case. In Telugu, I said by mistake rule in Rallens versus Fletcher. It is very popular case. Why it lies on the tongue. It lies on the lips of one's mouth. That is why that Raylan's case is professed very frequently. Sorry, friend, this is not Raylan's case. Rule in Clayton's case. What is this? Here, dear friends, we know this appropriation of payments. It is quite common in our human life. For example, we take provisions from provision shop. One day we take first week we take 5,000 articles. Second week we take some 2,000 articles. Third week some 1,000 articles. Totally in entire month, the total bill is some 15,000. So next month salary, if we pay 15,000, no problem. The entire liability gets closed. Similarly, it may be for 1 month pay period, or it may be some trader and customers. So the period may be 3 months. For some people, it may be 6 months. For some people, it may be 1 year. For example, the agriculture people get income once in a year. Some agriculture people get income in once in 6 months. Similarly, traders. So like this, the period of taking loan, taking advance or in cash or kind on different occasions, and repayment will be made on one. If repayment is made full 100%, there is no any adjustment. If repayment part payment is paid, how this part prepayment is to be adjusted is to be questioned. For example, and from January to December, A lent A supplied goods or money to B. B, he took some 10,000 in January, 15,000 in February, 20,000 in March, or 5,000 in April, like this. So B borrowed from A in cash or kind on different occasions from January to December. And at the beginning of next year, B pays some amount. The total liability is around 55,000, for example. If B repays 55,000 at a time, all loans will be, all debts will be cleared at a glance. Suppose B doesn't have that much money, B has only some 20,000, B repays 20,000 to A. How this 20,000 is to be appropriated is to be done according to the direction of the debtor. B, who is the debtor, who received different loans from A, will give instruction. I am giving you 20,000. You credit this 20,000 against a particular debt. It may be December debt or November debt or October debt or January debt, whatever it may be. If debtor specifically tells that this particular 20,000 should be appropriated on a particular amount, then the creditor has to appropriate it, adjust it at a particular date, whether it is in the first month or middle month or last month. That is first rule. But otherwise, the debtor tells creditor. The debtor tells creditor. This is 50 according to 59. That is expressed. This is implied. I am giving you 20,000 rupees out of 50,000. Which debt it clears 100%? If it is a debt in January, debt in April, and a particular debt in July, what debt this completely clears 100%? You do it. You repay, you adjust it. Suppose in October 15, B borrowed 20,000 worth goods. This 20,000 should be adjusted or appropriate against the debt of October only. That is implied. So implied means against what debt this 20,000 repayment gets accommodated, gets appropriated, is to be taken into account from first month to the last month. That is implied as per section 59. 60. 59 is our express and implied direction by debtor. According to section 60, the debtor doesn't give any instruction and will tell the creditor, I shall pay you 55,000, I am giving you 20,000, adjust this amount as you like. Then creditor has complete discretion to adjust it against any debt. Or he may split that 20,000 into various debts from January to February, because if he splits that 20,000 among various debts little by part payment, this part payment will give extension of the limitation period of 3 years. From what date this part payment is made, from that the limitation period extends to increases to counted for 3 years from the date of that part payment, as per section 18 and 19 of Indian Limitation Act 1963. So against what amount, what payment it should be adjusted, it is absolutely left to the discretion of the creditor. Third one is, if the debtor doesn't tell anything, creditor doesn't tell, but the creditor must see that he should not adjust any part payment in respect of a disputed debt. Disputed debt means the creditor tells that debtor should pay. Debtor tells that he need not pay. Such debt is called disputed debt. Next one is, last one is, the 61 is, if debtor doesn't tell any instruction and creditor doesn't think of any mode for appropriation, the repayment made by the part repayment made by debtor will have to be appropriated against the in chronological order. Chronological order means earliest debt must be cleared first, later debt must be cleared later. This type of 3 rules enshrined under section 59, 60, 61 were laid down or coined for the first time in a leading case. In the year 1816, Devyans versus Nobles. In this particular case, these 3 rules were coined. In this particular case, what happened was, Devyans and versus Noble case, what happened? The Devyans and others, 4 partners, were conducting partnership business. Out of the 5 partners, senior most partner, Devyans died. After the death of Devyans, the firm continued. One customer, Mr. Cladden, was maintaining some deposit in the joint in this firm, and as on the date of death of Devyans, he has some particular balance, say some 50,000 pounds, for example. And after 1 year, the firm was closed. Dissolved. Then, when the firm is closed, there were excess of liability over income. Assets are less, liabilities are more. Then this firm partners instituted IP, insolvency petition, and this firm was adjudged as insolvent, and all the assets of the firm were handed over to an official called official receiver. In England, in India, we call it insolvency. In England, it is called bankruptcy. Whatsoever may be, all the assets are given to the official receiver in India, official attorney in England. That official receiver will take over all the assets and distribute among various creditors on the principles of fully secured, partly secured, preferential, bills receivable, and ultimately unsecured creditors come. When once unsecured are come, at the time of death of Devyan, his estate is to be taken over by official attorney for distribution of the liabilities. Then this Clayton maintained some 50,000 pounds at the time of death. Subsequently, he withdrew some amount, and again he added that he deposited that amount. Then, as per since Clayton withdraw out of 50,000 some 30,000 pounds, his balance lies only 20,000. Out of 20,000 pounds, 10% means some 2,000 pounds will come. But the Clayton claims that no, it was 50,000. Subsequently, I deposited 30,000. You assume that it is only 50,000 pounds and give me 5,000 as per 10% like that he claims. No, that is not right. Suppose the bank gives you interest from first date to fifth date, 31st date. What is the maximum amount? What is the minimum amount there from date of first day to last day? What is the limit? Some one day more balance, other day more balance. They take into consideration lowest balance only. Lowest balance only. If some 50,000 is highest balance, lowest is 2,000, 20,000. But next day first, if the customer pays that whatever is withdrawn, if he claims give me interest as per 50,000, bank will not agree. What is the minimum balance lying in your account in that particular month? 20,000. Even if you put 50,000 or 1 lakh, it is immaterial. It will go to next month only. Like that, the banker will tell you. Accordingly, in this particular case, the court coined, passed 3 rules, laid down 3 rules. These 3 rules are incorporated in Indian Contract Act under section 59, 60 and 61. 59, 60 and 61. These rules are popularly known as rule in Clayton's case. These rules are incorporated for appropriation of payments and prescribed as section 59, 60 and 61. With these 3 points, discharge of contract by non-performance is over. Now we proceed to discharge by contract by performance is over. Now we proceed to discharge of contracted by non-performance. First one is the doctrine of frustration. Doctrine of frustration means impossibility of contract. No, impossibility impossibility of is called impossibility of contract. So here discharge of a contract by impossibility of performance is according to section 56 of the Indian Contract Act. According to section 56 of the Indian Contract Act, an agreement to do an act impossible in itself is void. Section 56 of the Indian Contract Act enunciates that an agreement to do an act impossible in itself is void. If the parties enter into contract which is with the performance which is impossible and cannot be done, it is said to be void according to 56. So this is supported by 2 Latin maxims, lex non coget and impossibilium. Law does not recognize what is impossible. Lex non, so whatever act is impossible, the law will not recognize. Similarly, impossibilium nulla obligato est. What is impossible does not create any obligation. Law does not create. There is no obligation is not entertained. These are the 3 questions. Basing on these 3 principles, the doctrine of frustration was enunciated. Section 56 speaks about if any act is impossible, law will declare it void. And 2 maxims. One maxim tells that law does not recognize any impossible act, and similarly, so the law does not create any obligation in respect of impossible act. With these things, this doctrine of frustration or impossibility of performance is very important topic from examination point of view. Essay question may be asked or short question may be asked. Now, this impossibility takes place in 2 ways. Number 1 is initial impossibility. Number 2, subsequent impossibility. Initial impossibility is subdivided into 2. Impossibility known, impossibility unknown. That is the whether impossibility is initial or subsequent, impossibility are known or unknown to one party or both the parties. All the cases, initial impossibility with known or unknown, one party, both the parties, whatever it may be, if impossibility exists, that contract is rendered void. It is no more valid. It is void ab initio. Subsequent. What is present impossibility, initial impossibility? What is subsequent impossibility? Suppose a doctor agrees to give life to dead child, or the doctor agrees to give treatment to a cancer patient who is about to die in a few days. That such contracts are impossible. If a runner gives an agreement to run 100 kilometers in 100, it is initial impossibility. And subsequent impossibility, obviously it is known or unknown. Known or what means? Known means tangible, unknown means intangible. A patient may be looking very handsome, but his eyes, nose, everything is good. There is no any defect. But he is suffering from kidney trouble or lungs trouble or heart trouble. That is intangible. So the kidney trouble, lungs trouble, and detected by a medical examination only. So that is why known and unknown. So subsequent impossibility. Subsequent impossibility means A agrees to perform one contract, construct the building. Suppose the builder is ready to give possession within 1 year, but due to COVID pandemic, there are no workers, no work, no transport, lockdown, everything. He would not be able to give possession even in 3 years. If any purchaser challenges, the builder is protected on the protection of COVID-19 pandemic and lockdown issues. That is impossibility of performance. He cannot construct with his own hands because workers are not there. The workers are scattered at different places owing to lockdown. They would not be able to come down. This defense can be pleaded. That is subsequent impossibility. At the time of entering into contract for allotting flats, normal time is there. When the construction is in progress, COVID pandemic appeared, and that is subsequent impossibility. Similarly, a painter is ready to complete that work. Subsequently, he fell ill due to some ill health or some accident. That is subsequent impossibility. The subsequent impossibility also may take place. Today, the supply of consumption of alcoholic drinks is okay, and after that GO comes abolishing the same. Then it is subsequent impossibility. Subsequent impossibility. In this case, there is a leading case on this point is Taylor versus Caldwell. Taylor versus Caldwell. It is 1863 case. In this case, what happened was, the defendant in this case was having some music hall. Plaintiff wanted to hire the music hall for some entertainment performance on some future dates. And he gave, just like for marriage, we book the Kalyan, function hall well in advance. In the meantime, the function, some fight took place in that function hall. He won't be able to give. We cannot file a case against the owner of the function hall. Similarly, the plaintiff booked this music function hall for some music performance on various dates. In the meanwhile, fight took place. The function hall was destroyed, music hall was destroyed, and plaintiff brought an action for which defendant pleaded that I wanted to give on hire on particular dates. Meanwhile, fight took place and my music hall was destroyed. I was impossible. The condition of the defendant was accepted. So this is on the ground of impossibility of performance. Next one is first one. Second one is subsequent impossibility. Second one is subsequent impossibility of subsequent impossibility. Similarly, death to insanity, break of war. All these things also will be taken as a subsequent impossibility. Next one is, the second topic is subsequent agreement. Discharge of contract by subsequent agreement. This discharge of contract by entering into subsequent agreement is provided under Section 62 of the Indian Contract Act. Section 62 of the Indian Contract Act speaks about novation. But here, under the existing contract is closed and a new contract is created. So the closure of old contract becomes consideration to the new contract. This doctrine of novation, subsequent agreement, takes place under four situations. First situation is parties same, terms and contract is same. So promissory note is there. A and B enter into promissory note for 1 lakh loan. So 3 years is elapsed. Before completion of 3 years, B approaches A, the promissory note will be valid, I am not able to repay. What happens is, my friend C shall pay me some amount. He will write a fresh promissory note for 1 lakh. So terms of the contract say parties changed. Earlier contract between A and B, now contract between A and C. So parties changed, terms and conditions the same. Secondly, B tells I have no money. I have no money to pay, but my son, my friend C will give you some gold chain. You take it. Enter into contract. Now here, what happened is parties changed, terms and conditions changed. Old contract promissory notes is closed. Second, new contract pledge is cleared. Third, A and B. No, I have no money. I will give you my gold chain. Keep it as a pledge and close the old contract. Old contract promissory note is closed. New contract between A and B is created. Parties changed. Terms of contract change. Third one. Fourth one is parties will change. Terms and conditions will change. So these are the four. So my son, my friend will give you money. Will keep his house or for rent, for house for mortgage, and parties will be changed. Terms and conditions change. Four situations. Same parties, same terms and conditions. Second party, same terms and conditions. Parties change. Third condition, terms and conditions, parties same, terms and conditions different. Fourth situation, parties change, terms and conditions same. These are the four situations under novation. These are the four situations under the novation. So this is an important topic for examination for short notes also. Third one is remission. Remission means the creditor is doubtful about the repayment of the debtor, and the creditor will give some remission, just like offer 25,000 TV for 20,000, like that. So the debtor owes 1 lakh from creditor. Sometime 3 years is about to be completed. The creditor will ask the debtor, you shall pay me 1 lakh. You took 1 lakh, interest is 30,000. 1 lakh 30,000. You need not pay me interest. You pay me only principal enough. So that offer made by creditor to debtor is called remission. By that the debtor will pay 1 lakh and clear off against in settlement of 1 lakh 30,000. This is what is called remission. Fourth one is accordant satisfaction. Accordant satisfaction. The seller enters into agreement with the buyer to sell his house for 50 lakhs. 50 lakhs. Then the purchaser is delaying the process to pay money and purchase it. The seller feels that the purchaser is not willing to purchase because maybe reason he doesn't have money, or maybe the reason he is not interested. If I reduce it from 50 lakhs to 40 lakhs, he may come forward. So then the seller reduces the price from 50 lakhs to 40 lakhs. That is what is called an act of accord made by the seller, for which satisfies the buyer to come forward to purchase. That is called satisfaction. So this is the other way the contract gets completed. So by non-performance by breach completion of the contract. Fifth one is the breach of contract. Breach of contract means failure to perform the contract. A and B enter into an agreement for sale. B doesn't pay money, it is breach of contract. A doesn't, after receiving advance, A doesn't sell, it is called breach of contract. When seller breaches because a 50 lakh house rose to 75 lakhs or 80 lakhs, the seller may be reluctant to go for registration. That is what is called breach of contract. Then purchaser can institute an action against seller for specific performance. Then the seller should perform that contract. Otherwise, the act of seller not to deliver the house and register the house is called breach of contract. But the purchaser, having accepted to purchase the house for 50 lakh, is postponing the matter for unlimited time. That is what the act of purchase is called breach of contract. Breach of contract means failure to perform the contract or non-observance of the contract. Non-observance of the contract renders the contract void. So here, this breach of contract, if a breach of contract takes place, the aggrieved party will file a case against the wrongdoer for specific performance. This breach of contract breach is of two cases, two categories. One is present breach, other is anticipatory breach. If buyer doesn't like to buy, it is breach of present breach. If seller doesn't like to deliver the house and register, it is present breach. There are certain circumstances in which there will be a future breach or anticipatory breach. For example, if you take a loan from bank or insurance organization to purchase a flat, the people book the flat at the time of foundation stone when the building is in construction. So suppose the customer purchases a flat from a builder for 1 lakh, 50 lakhs, and bank or insurance organization, insurance finance company sanctions the amount for 50 lakhs. So the loan is sanctioned in first installments, first floor time, the bank will pay some 10 lakhs. The moment 10 lakhs is paid, immediately the customer is asked to pay the installment, maybe for 10 years, 5 years, 20 years, whatever it may be. The installment starts. So the customer should pay the installment regularly and periodically without any default. If the customer regularly pays, then when the building comes for second floor, another 10 lakhs is paid. Third floor, another 10 lakhs is paid. Finally, finishing time, some 10 lakhs is paid, like that. In 5 phases, the money lender, banker or insurance finance organization will pay in 4 in 5 when the amount is utilized by the builder in different steps. However, the customer must pay the installment regularly, promptly, periodically. If the customer doesn't pay the installment regularly, periodically, the lending organization, banker or insurance finance company will stop release of further payment to the builder. That is, then builder will cancel the flat. So similarly, the customer is paying regularly, the bank is not paying properly. That is a breach of. So this type of non-payment of non-release of amount by banker or financial organization called anticipatory breach, or non-payment of improper payment or irregular payment by customer also will become improper breach. So this is what is called a anticipatory breach. 5th point is over. Now 6th point is discharge by lapse of time. The offeror gives time to the acceptor promisee. The promisor gives time to promisee a particular time. If you come and take the article within an hour so and so date, then only I will give. Otherwise I won't give you. That is the promisor gives some time. So or reasonable time as per the case. The offer remain valid for a particular time as per the terms of contract, or for a time as per the reasonable. Suppose mangoes are offered for reduced price, to A offers to give his mangoes at 300 rupees dozen for particular that. The offer can remain valid for 2 days, 3 days or 5 days. But he should purchase them within 2-3 days, otherwise they will become the perishable product. It will vanish. That is it. So time. Similarly, the limitation period also is there. By limitation period, the contract may be discharged. By death, insanity or anything, the contract may be discharged. Lastly, 7th point is, that is lapse of time. 7th point is contract may be the contract may be discharged by operation of law. By operation of law, death, insanity, insolvency, breakup of our alien enemies, and all these instances come within the meaning of operation of law. If new government or new legislature passes a law which renders existing valid contract illegal or void, then only due to operation of law also the contracts may be rendered invalid. For example, yesterday the contract between A and B with reference to supply of wines is valid. Today new government came and passed new GO, consumption of alcoholic drinks is banned. Then yesterday's valid contract supply of wines is rendered invalid today. So similarly today A in country X, B in country B are doing export and import business, legitimate business, legal business, but the A war broke between the countries A and B, between X and Y countries. A and B cannot continue their business because they are alien enemies. These are the 7 topics under non-performance of breach of contract. Dear friend, totally there are 10 items for breach of contract. In performance, 3 items are there, namely offer or tender of performance with reference to reciprocal promises. Second one is performance of contract by joint promisors or joint liability. The second one, 42 to 44 of Indian Contract Act. Third one is the rule in Clayton case or appropriation of payments or devolution of liability by debtor, where debtor takes various debts and makes part payment. How this part payment is to be adjusted among the debts already taken on different dates is the topic. This is also popularly known as rule in Clayton's case. As these rules were laid down in a leading case, Davian Davis versus Noble in England. So this is performance. In non-performance, there are 7 points are there. First one is Doctrine of Frustration, section 56, with particular reference to section 56, clause 2. Second one is discharge by subsequent agreement. Third one is discharge by remission. Fourth one is discharge by Accordant Satisfaction. Fifth one is discharge by breach. Sixth one is discharge of contract by lapse of time. And the seventh one is discharge by contract by operation of law. These are the 7 points. Out of these, Doctrine of Frustration is most important. Next, Novation is important. Next, Appropriation of Payment, rule in Clayton's case. Then joint liability. This joint liability is common for each and every subject, civil law and criminal law. For knowledge point of view, one must know about this. This topic has been completed. Thank you very much, dear friend. Please concentrate on my lectures. You will become, I promise that those who watch all my lectures will acquire wonderful knowledge. You can directly, if you have enough language vocabulary, comment in English. You can straight away put practice in High Court or Supreme Court. I assure you that my lectures are, I very sincerely doing this work with very hard work as a matter of challenge. Please keep in mind and work hard. Thank you very much.